I think in many ways it's overhyped, and particularly right now, there's a lot of FOMO going on, which is a little unusual for the legal community. Lawyers and legal professionals are usually pretty slow to adopt technology or to be excited about technology. But they seem to be sort of at least saying that they're going overboard, or seeming to go overboard. That's what their statements indicate. Whether they are or not, that's a different issue, which we can come back to. I think part of the problem is there are a lot of the risks with AI in the legal tech community are being ignored.
Welcome to Between the Briefs, a podcast by Steno. We're here to bring you practical tips, expert insights, and real conversations about the pretrial process, court reporting, and the legal technology shaping the future of litigation. I'm your host, Adrian.
And I'm your host, Joe Stevens. Whether you're an attorney, paralegal, or just curious about how technology is changing the legal industry, we've got something for you. Each episode will break down complex topics, share behind-the-scenes intel, and talk to the people leading innovation in and out of the courtroom. So grab a coffee and let's get into what's happening between the briefs. Welcome to Between the Briefs, your go-to podcast for legal innovation. I'm Joe Stevens.
And I'm Adrian. Today, we're honored to be joined by Steve Embry, lawyer, writer, national litigator, and the voice behind Tech Law Crossroads, a no-nonsense blog examining how technology and innovation are colliding with the traditional bound legal profession.
Steve brings a rare perspective shaped by decades of litigation experience and deep involvement in bar leadership, including his role as chair-elect of the ABA Law Practice Division. His work cuts through the hype to focus on what technology actually means for lawyers, law firms, and the future of legal practice.
Steve, welcome to the show. We're thrilled to have you here today. How are you doing?
Doing great, thank you. I'm thrilled to be here. It'll be a lot of fun.
Definitely. I'm really excited to dig into it. So for anyone in the audience who doesn't know who you are, tell us a little bit about yourself.
Sure. I practiced law full-time for a good number of years, more than I'd like to think. I was with what was then an AmLaw 200 firm. I think it's probably an AmLaw 100 firm now. And I was a mass tort defense lawyer, represented a lot of corporations and companies across the country and in cases across the country. And that spawned my interest in technology and what it can do, because I was essentially working remote full time. And in fact, it's always kind of funny. I would get calls from time to time about cases in the jurisdiction where I practiced and about particular judges. And I don't have a clue. I haven't had a case here in 20 years. But that spawned an interest in technology and remote working, which requires technology. It was a bit more of a challenge in those days. But as I became more and more interested in technology, I started writing about it, first on LinkedIn, and then I started a blog, which is Tech Law Crossroads. And it wasn't that I was dissatisfied practicing law or unhappy practicing law. It was more that I enjoyed writing about technology and the sort of the intersection between the legal practice and technology. And so I began doing that. I decided to do that full time. And as a result of that, I left the practice, or left the firm that I was with, and just started writing. And that's kind of how I got to where I am today. And it's been a fun ride. I'm not one of those people that likes to say I'm a recovering lawyer. I enjoyed the practice of law. I enjoyed the cases. I miss it from time to time, but what I'm doing now is more enjoyable and more fulfilling, and so that's where I am.
Steve, take us into the blog for a second. I mean, if you had to describe it and the sort of the tone, the subjects you like to tackle, the method behind your writing and what you're trying to convey, maybe be a little bit specific on some of those areas and throw a few examples out there for everyone.
Yeah, sure. I'll be glad to do that. When I first started writing, or first started the blog, I was looking for a voice, looking for what I could add that would be unique or different. And I was at Legal Week in New York around that time, and I bumped into Bob Ambrosi, who I'm sure you guys know, is very very well known legal tech journalist, probably the most well respected person in the field. And we were walking down the hall, and I grabbed him and I said, Bob, I'm starting this blog. What do you think I should write about? And he, without missing a beat, he said, "Write about what you know," and then went on about his way. And it occurred to me after that that what I know is the practice of law. There are not very many voices in legal tech journalism that have the actual experience of practicing for many years as I had. Which gives me, I think, a little bit of a unique perspective. I know how law firms work. I know law firm bureaucracy. I know how consensus decisions are or not made in law firms. I know the tensions. Uh, I know the how lawyers and litigators sweat in the middle of the night, and all of those things, I think, impact the use and value of technology in very fundamental sort of ways. And so that's kind of what I've tried to do. I'll try to bring that perspective to what I write. I've tried to include anecdotes, experiences that I've had that are reflect the points that I'm trying to make. And I think I'm reasonably successful with doing that. Sometimes I wonder, but I try to be very honest, sometimes brutally honest, and not resort to a lot of BS if what I'm talking when I write, which is, as you see from the blogs page, um, that's kind of front and center. So that's where it's been going, and it's been several years since I was in a law firm, but I try to stay close to law firms and managing partners. I'm in various defense lawyer organizations that keep allow me to keep that perspective, and so I still think I've got something to say that very few other people do.
You made a point that you try to keep close, put your thumb essentially on the industry and where everything's at. For any of our listeners who are new to legal tech and they really just want to get a good insight into what is trending, what is real, clearly your blog would be a great source of information. But is there any other places you recommend they go so that they can better educate themselves on it?
Sure. As you guys probably know, I write frequently for Above the Law, and there's some really outstanding journalism and authorship that go into that. In addition to that, Bob Ambrosi has a weekly legal tech journalist roundtable that I participate in. There's 5, 6 of us that are panelists, and each week we pick a story that we think is of significance in the legal tech community, and that's every Friday at 3 o'clock Eastern. Um, and it's a good way to keep up. Uh, Bob's stuff is really good. The Above the Law stuff is really good. The thing that I have found though is, when I first started, I was trying to write about everything legal tech, and that was a little easier when I first started than it is today. 'Cause there's a whole lot more stuff that's happening. It is like drinking from the proverbial fire hose. So I now try to limit what I'm interested in, what I write about, to things that are litigation oriented, which is, of course, my field and something I know a little bit more about. And so I think it's important for people that want to keep up with legal tech. It's important to define what you're keeping up with to the practice that you have or the interest you have. It's really easy to get really broad and not deep, particularly these days. But that would be my advice. You stick to the areas that affect your practice or affect what you're interested in, and if you're a vendor, what you're marketing, what you're selling, and try to not ignore the other stuff, but certainly keep a focus. The other thing I like to tell people when I'm asked that question is, don't limit yourself to just the legal tech stuff. There's a lot of things that happen in technology in general that impact legal technology pretty fundamentally. For example, every year I try to attend the what's known as CES. It's the Consumer Electronics Show that's held in January, along with 150,000 other screaming tech nerds. But it's useful to go to the things like that because you hear different perspectives and you learn new things. You kind of see where people are going, where technology is going, and so I try to do that as well.
Steve, what do you if we get into AI for a second, I'm really interested. You sort
What's
of
that? I've not heard of that. Is that something new?
it is. Yeah, it is. It's brand new.
Hmm.
You're gonna love it. What why don't you just kind of set up this part of the conversation here with a sense of like how you view AI? I mean, you obviously didn't your entire practice sort of existed predominantly without it. And now you're seeing it really upend this practice that you're still writing about. So maybe just start there and kind of give some overarching thoughts about what you're seeing and how you're reacting to it.
Sure. It's I think in many ways it's overhyped. Um and particularly right now there's a lot of FOMO going on, and which is a little unusual for the legal community. I mean, legal lawyers and legal professionals are usually pretty slow to adopt technology or to be excited about technology, but they seem to be sort of at least saying that they're going overboard or seeming to go overboard. That's what their statements indicate. Whether they are or not, that's a different issue, which we can come back to. But it, it I think part of the problem is there are a lot of the risks with AI and the legal tech community are being ignored. Um, and good friend of mine, Melissa Rogozinski, and I recently wrote a series of articles about that very thing, starting with just in general the infrastructure gap that exists with AI, generative AI in general. And when you look at it, it's a pretty significant threat because we could approach the time when a lot of um, AI tools, generative AI tools, aren't functioning well because either the data centers aren't there, or maybe even more importantly, the power is not there. Electrical power is not there to power every AI, generative AI tool that's in existence. And we're also starting to see some real investor cold feet with a lot of these underlying infrastructure tools. Because the thing you have to remember is when you talk about power, electrical power, you can't just say, "Oh, I'm gonna generate 7 times more power next year than I am this year because that's what the forecasted needs are with all these data centers." That takes a long time. You have to build a power plant, and you have to get regulatory approval for the power plant. Then you have to build it, and so that's a long time return on investment. And a lot of the investors these days are running into throwing money at a lot of AI companies, AI platforms, infrastructure platforms, and they won't get and that's based on growing demand. If the demand falters, then they're not going to get the return, then it takes a long time to get the return. So it's a compounding problem. So that's a risk. We have this sort of what we've called the verification paradox. Um, and that's based on some research that have recently been done. The question you have to ask is the time that I save using generative AI tools going to be sort of offset or more than offset by the time it takes me to verify all the outputs? And it's a significant problem, particularly when you start thinking about how legal works, how lawyers, sort of the workflow process that most lawyers and judges engage in, and that is senior lawyer gives an assignment to an associate. The associate does the assignment, does the research, brings back the product. The senior partner looks at the partner, reviews it, plugs it into a brief, boom, and goes. Uh, or a judge relies upon what a law clerk has done, or a local counsel relies upon what a national counsel has done. But now that we have so many people using generative AI tools, which are deceptively easy to use. I mean, they cut if you're busy and overwhelmed, they cut the times you need to spend, you know, exponentially. So then the question becomes: in any work product, are there hallucinations? Does the site have to be verified? Does the judge have to personally verify all the citations in the memorandum by the law clerk? Does local counsel now have to look up and ensure that all the citations of national counsel are to real cases and are accurate? Our whole legal output system, particularly in litigation, hinges upon being able to trust to a certain degree those that are working for you. And if we can't trust that, then that's a fundamental problem, and it's really not workable. You can't expect all these people that have depended upon this type of workflow to now all of a sudden have to redo all the research themselves, which of course then sort of says, well, why do you have a clerk or younger lawyer do it to begin with? You're still going to have to do the same amount of work. So, there's just some fundamental risks and issues out there that we haven't quite dealt with. And I think the thing that really worries me, quite honestly, is the temptation to rely upon these tools, to sort of replace our critical thinking skills and our natural skepticism as lawyers into the products that we have and the outputs that we're giving to our clients, to the courts. Particularly with all the hype and all the talk about how wonderful and how it's going to change the world, that's a problem, I think, and it's a temptation to people, particularly younger lawyers. Um, and I don't mean to be a naysayer on generative AI, um, but I do want to be realistic about what we could be facing as an industry, as a profession, uh, with these tools.
That makes me curious. What do you think is the solution then when it comes to wanting to implement a revolutionary kind of tool in terms of speed up time, the ability to analyze hundreds, if not thousands of documents at once, yet keep that check and balance of productivity and making sure everything that's being said is correct and whatever's being analyzed is correct? Do you think there is a good balance or a right way to do this so that you can still implement the software, but keep the integrity of your firm?
Good Good question, and it's two. I think there's two pieces to the answer. Well, one is how we do things as a profession, particularly with respect to training, and two, how we get paid for the services that we provide. Going to the first point, the how we do things. I was at one of the conferences I attend every year is AALL, which is the American Association of Law Librarians, which is a great conference. Um, but there was a panel discussion I went to, and on the panel were a couple of law librarians from large law firms, and they made a very interesting point. And the point was that they had discovered that more experienced lawyers with an understanding of generative AI tools and how they worked, were much better at A, constructing the prompt to ask the right question, and B, recognizing when the answer didn't look right or didn't sound right or something was off about it. And the as I thought about that, that makes sense because uh, the more experienced lawyers are used to thinking critically and carefully about things. They're used to formulating the problem. that needs to be solved. They're experienced in handling cases, handling matters, handling clients. Um, when I was a young lawyer, I would be given assignments to go into warehouses and read through boxes of documents, like real paper documents. We don't see those much anymore, but they used to exist. And I often thought, why did I go to law school to do this junk? This is stupid. And even today, I've hear a lot of lawyers say that's that kind of work didn't do anything to train a young lawyer to be a better lawyer in the future. It was just scut work. Um, but I do wonder whether some of that scut work, that is, as we call it now, was useful in making me be a better lawyer. We hear a lot about gut instinct, particularly when you talk to more experienced lawyers, that they will say, "I just kind of have my gut feeling is this witness is not telling the truth," or "My gut feeling is there are more documents out there." And I don't think that's gut feeling. What I think it is an experienced lawyer has seen patterns of activities, patterns in situations that make them think, this sort of looks like that pattern I saw in this case, and that makes me think that maybe this witness is not telling the truth, or maybe there are documents that have not been produced. So maybe all those all those times looking at documents, reviewing documents over the years, enabled me to see those kind of patterns, to see when this document looks like this, that probably means there's going to be 5 or 6 other documents that have similar but slightly different things in them. And if those documents aren't there, then we've got to ask for them. Or if they are there, I'm going to find them. Or if they're missing, there has to be a reason. So getting back to the question, how we do things. I think on the one hand, we have a magnificent opportunity to use these generative AI tools to enable younger lawyers to do much more than they couldn't do before. Take the deposition they couldn't do before, because the tools can help them formulate the questions, and know where to go, know how to do it, formulate all these kinds of things that we've all talked about: strategy, vision, uh, what are the best approaches, all these kind of things. The trick, though, will be ensuring that the younger lawyer just doesn't rely on those outputs, doesn't take that list of questions for the deposition and go to a deposition and just start asking them and not listen for the answer, not follow up when it needs to be followed up. To get there, I think there has to be a senior lawyer in the loop. I think we always talk about human in the loops, but I think the way senior lawyers are going to have to train younger lawyers is going to involve much more. Let me see what the output that you got from the generative AI tool. Let me see the tweaks that you've made. Now let's go over these questions, and I can tell you why you should ask this or not ask that. That's a good question. That's a bad question. Uh, here's where you need to dig in. Here's where you need to let it alone. And those kinds of things, I think that's the kind of sort of mentorship that we're going to have to teach, to make sure the younger lawyers get these critical skills, to make sure they don't over rely upon um, the generative AI tools, because that's a real danger. The other piece of it I alluded to is how we pay for things, how we get paid for things, and that is a real issue. I recently wrote an article about this very point, and it's you run the math. Let's say a lawyer bills $300 an hour. It's going to take him or her 25 hours to draft this brief. Do the math. I don't know what that comes out to, but it's a significant figure. Okay, now they can use a generative AI tool, and instead of 25 hours to write the brief, they spend 10. Okay, so you run that math, and then that's a big difference between what you get paid on the one hand and what you get paid on the other. And I'm not sure you can bridge that gap by just raising your rates. I don't think clients are going to stand for that. So that would suggest that the billable hour model has some really, either one or two things have to happen. We either have to change how we bill, or we have to get prepared to uh, make less money on what we're doing. Answer to that is often, well, there's going to be more work to do. I think that's true in the short run. I don't think that's true in the long run. So something's got to give somewhere, and we would be wise, I think, to begin looking at other ways to value the kind of services that we provide, other than just billing by the hour. When we have tools that reduce, by definition, reduce the amount of time that you're going to spend working and billing. So
Steve, you talked a little bit about the need for younger lawyers to sort of, I mean, their skill set is being reformed. It's a critical part of their development when AI now jumps in and does a number of things. I see this with my students. But yet, at the end of the day, they still, need to, depending on what kind of work they're doing, they need to stand in front of a judge. They need to negotiate with a prosecutor. They need to be able to listen to a witness and course correct and all of those things, right? So you talked about that. There's also something else about, I think, the skill set of a more seasoned practitioner, right? I mean, you have this collision of mindsets now at these firms where you have the younger practitioner with the skill set you just described, the more seasoned practitioner who doesn't really know maybe the ins and outs of the technology, but has the instincts and the training and the understanding. Those two worlds, when they collide, that makes for some interesting dynamics, I suppose. And I'm curious what you think what adjustments need to be made by the sort of more seasoned practitioner.
yeah, it's I do talk about this a lot, and not to bring up a sore subject, but ethics. uh, I often will hear senior lawyers say, "I'm just too old for that kind of BS. I don't need to learn about it." Okay, that's fine, but if you supervise anybody, younger lawyer, paralegal, administrative assistant, you name it, anybody and everybody in your office that you have supervisory responsibility for, you have an ethical duty to make sure that they comply with ethical duties, that they protect client confidences, that they serve their clients appropriately. If you know nothing about the tools that they're using to do that, query whether you can satisfy that ethical duty. I think it's folly for senior lawyers to ignore these tools. Uh, and act like A, people aren't going to use them, or B, they don't need to know about them. In addition to the ethical responsibility, there's a practical reality. Clients, particularly business clients, are going to begin using these tools more and more. And I interesting piece I did this week on a survey by a global insurance company of the risks that most of their insureds, uh, consultants, underwriters, people involved in the industry and business believe are the most significant in the coming year. And the two that were the most significant were cyber threats, which we obviously is what we know about, but artificial intelligence. And they're worried about the risks in implementing artificial intelligence. They're worried about the liability risks. They're worried about what agentic AI is going to do to the risk to their business as these platforms begin making decisions on their own, hopefully not totally on their own. So the business people are concerned about this. If you're a senior lawyer and you have business clients, stands to reason that if that's what's keeping them up at night, it damn well better keep you up at night, or you're not going to have any business. It's kind of as simple as that. And so now, sort of a more fundamental issue is the different markets that lawyers practice in. Often when I'm in podcasts like this, or generally, or in writing, uh, I talk about what I know, and that is large law firms. And much of what I've just said pertains to large law firms with business clients, corporate clients. There's a whole different industry out there, several different industries. Small firms have a completely different business model. Many of them bill by the hour, but their expenses and the clients they serve are completely different than these large law firms. And so for them, they need to think of these tools maybe not so much in how much it's going to cost me in reduced hours, but how I'm going to be much able to compete with larger law firms um, as a result of these tools. And we're starting to see some of that happen as particularly in litigation partners in very large law firms and law 50 firms are beginning to migrate to more mid-sized firms and taking their practice with them because the clients, they can reduce their rates, uh, uh, make more money, be happier, and still compete just as well with anybody. And that's what these tools enable us to do. Then you have the plaintiff's contingency firms, which again is a totally different market because for them, the AI tools are in nirvana, right? When you think about it, because for them, an hour saved is, an hour earned, it's dollars earned. And what we're seeing with their adoption is really interesting because what a lot of plaintiffs lawyers have now done and what generative AI enables them to do is take cases that they couldn't take before because the cost and the benefit analysis just didn't work. Costs were too high to litigate the case. You cut those costs back by X amount percentage, and now the you can make a profit on them. And we're seeing an increase in litigation as a result of that. How long that'll last it is anybody's guess. And I don't think it can last forever because there's only so many of those cases. But it is a phenomenon. So you have to be careful when you talk about all these things to define which legal market you're really talking about, because the impact of what they're doing can be completely different.
You went all in on creating your blog, right? The tech law crossroads. What about writing do you feel makes you a great writer, or just in general, what makes a great writer? And on top of that, do you think being a lawyer helped make you a better writer?
Yeah, that's an interesting comment, and if you'll indulge me, I will tell a personal story about it because I think it's interesting. When I was in high school, I was a very quiet. I mean, it's very hard to believe now, but I was a very quiet person, and people would often comment how quiet that I was, how I didn't say much, and to the point that when I said, "What do you want to do when you grow up?" I want to be a lawyer. How could you be a lawyer? You never say anything. And I had an uncle who didn't have a high school education, physical laborer, and I was talking to him about it one time, and I was sort of bemoaning the fact that I wanted to be a lawyer, but most people think I could never do it because I was so quiet. And he said, "Well, are you a good writer?" And I said, "Yeah, yes, I'm a good writer." And he said, "That's all you need to be a good lawyer. Just be a good writer." And I took that to heart because it sort of spurred me on to become ultimately a lawyer, and probably not a very quiet one at that. But there's a lot of truth to that. Writing, you have to organize your thoughts. You have to figure out the most important thing to say. You have to say it in a way that's brief and concise and hits home. And you have to make it into a story kind of form. And that's what good lawyers do, particularly litigators. That's what we do. We tell stories. We tell them as succinctly as we can. We tell them in a way that engages people's interest. That's a good lawyer, and that's good writing. So I tend to think it's still a super important skill. Um, the danger that we now are getting to is uh, generative AI tools can write stuff for you. And a lot of times, at least for now, you can spot it most of the time, particularly if if too much of it in a writing. How much that'll be in the future, or whether we will just all come to accept writing slop, remains to be seen. When I write my articles, I'll always write the first couple of drafts myself, always. Um, then I will ask. I usually use Claude because I've found it the best for a couple of reasons for editorial comments, some of which I accept, some of which I don't. It catches a lot of grammar flaws. But one of the reasons I like to use Claude as opposed to Chat GPT, if you ask Chat GPT for editorial comments, unless you tell it otherwise, it will not only give you the comment, but it'll rewrite whatever it's commenting on for you. Claude, on the other hand, most of the time says, uh, "Steve, buddy, this paragraph is all messed up. It doesn't flow right. You need to fix it." and stop, which I like because now I have to fix it in my own voice. And so, I, if 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 you're a writer and you're going to use generative AI tools, it is so important to start with your voice. Um, Now, some people say, "Well, I'll let it do the first draft, then I'll put it in my voice." Maybe you can do that. That doesn't work very well for me personally, but it's possible. But it's got to be your voice. There's an old adage for litigators, for trial lawyers, who what do I have to do to what's the first rule for trying cases? Be yourself. Don't try to be something that you're not. Don't try to be Clarence Darrow when you're Steve Embry, right? And the same is true with writing. I mean, that's if you want it to resonate with people, they have to know that they have to get the sense this is authentic. He didn't just pop this out of Chat GPT or Claude and stick it on there and walk away half fat, dumb, and happy.
What do you think? This is an area. It's kind of a softer area, Steve, that I'm always interested in. I mean, there's so much value that can be brought when it comes to like just time saving, all the things we've talked about with it. But then you're talking about like losing something that's almost intangible, right? Getting AI to help you, but then having to add your voice back in or tweak your voice, or not going through the process of sitting down, staring at a blank page and being like, how am I going to structure this? How do I get from point A to what is compelling? What's too long winded? What's too short winded? Like that process for the last however many thousand years has been roughly the same. And then all of a sudden we have, this thing that allows it to completely be disrupted. And I'm just wondering, in your mind, what is the thing that is lost by that? Like what do we lose when someone does not have to wrestle with the blank page like that?
Yeah, and I think it's what I just talked about, the authenticity. Um, i- the way you write is different than the way I write, and you could write an article on uh, Chat GPT and hallucinations, and I could write same article. We could give it to Adrian, and he would know which one is which, right? I mean, or he'd at least say these were written by two different people. Um, the thing that I most worry about is the sort of the dumbing down of the work product to the point that we all learn to accept the generative AI product, to think that's the norm, to think that's acceptable. I was giving a presentation on AI one time, and somebody in the back room or back of the room raised their hand and said, Do you think that Chat GPT or generative AI could write in the style of Ernest Hemingway?" And I thought for a minute and I said, maybe, but I tell you one thing it can't do. It can't write in the style of the next Hemingway. And the reason I said that is because if you know much about Ernest Hemingway, his writing style was unique. He wrote in a way that nobody had ever written before. I mean, and even today, when you read one of his books, you pretty quickly say this is Ernest Hemingway. I mean, nobody else writes like that even now. Um, so I don't think our tools are at the point. I'm not sure they'll ever be at the point where they can make that kind of creative leap and do something completely different to create an image like the next Picasso would create. It could create an image like in the past, but these artists that have come along, they completely changed the game with the way they do things. The difficulty is if we as a society or profession rely totally on generative AI tools to do all this work for us, where is that next leap in creativity going to come from? Um, and how will it be accepted? Or can it be accepted? That's one of the worries I have just philosophically about these tools, and it's a worry that I mean it's one of those things that's just there that we have to think about. It's not going to go away. It's not going to no, we're not going to turn the generative AI tools off tomorrow and go back to the way we were 20 years ago. That's not going to happen. So we have to be thinking about, okay, how are we going to help ensure that that happens? And I think a lot of that starts with education, with training, with identifying the issues that we as a society agree are present, and how to tackle those issues.
Now, Steve, I think this perfectly leads us to a question that we always ask towards the end of our conversation, and that is, what is your hottest take on the industry right now?
I think the hottest take on the industry right now is sort of the rush to embrace generative AI tools. The sort of the glossing over of real issues, the failure to sort of understand the distinction between artificial intelligence generally and generative AI specifically, the notion that all AI is generative AI, so only generative AI solutions will work for what we need to have done. It's this over embracing uh, in actuality maybe, but certainly in what we're saying, that I think is a little dangerous and a little concerning. And that, to me, that's the hottest thing is the vendors and the hype is perhaps getting out ahead of the reality. And the thing is, and I mentioned earlier on that I've never seen before is um, the legal profession sort of making that leap along with everybody else. I mean, always before, you know, the cloud, right? Remember the cloud? We're not putting shit in the cloud. Are you out of your mind? We got to have it right here with us so we can use it. Uh, and that drug or tar, that I mean, we still have people that say we can't use tar, right? So that and we laugh about that, and we say, aren't lawyers, like sticking their heads in the sand? But there's some value in that because I mean it tested those things. We tested the cloud and we found the risks and we corrected them and now we can rely on it. And I worry that, with generative AI, I'm concerned there's not that same amount of skepticism and testing that is going on. Now, there's also the possibility that a lot of law firms and lawyers are, saying they're adopting all these generative AI tools without necessarily adopting all these generative AI tools. That's also a possibility, but that has its own risks, and it still creates this sort of notion that the only way that we can practice law today and in the future is if we go all in on generative AI all the time, and that's bad. That's not correct. That's not true. So that's to me, that's the hottest issue. Like you said, the hottest thing. I turned it into the hottest issue, which is a little bit of a twist, but that to me is the most concerning thing as of right now.
I love it. That's a great hot take. I feel like this coincides with what we're seeing a lot right now in the industry, even with concepts like dead internet theory, where a majority of the content that is on the online is soon to be just generative AI speaking to one
Yeah,
another.
yeah.
So that
More
is a
slop.
more slop, exactly. So there needs to be some guardrails and more human innovation and creativity coming out, so that way we don't get to that point. So that is a great hot take.
Thank you.
Thank you, Steve. That's a wrap on today's episode of Between the Briefs. A big thank you to Steve Embry for bringing his
Thank you.
candid perspective. Of course, of course. Thank you for joining us. We loved your perspective on legal innovation, the cultural tension between technology and tradition, and the practical realities shaping the future of the law practice.
Yeah, Steve, it was an absolute pleasure. Thank you so
That's
much for
fun.
joining us here
Yep.
today. And to everyone who's listening, we'll catch you next time.
Up next on Between the Briefs.
The pressure on firms to do more with less or do more with the same is ramping up, but the cat's out of the bag at this point. Everyone knows at this point that AI is going to have a big impact on law. It's still sort of subject to debate, what this all looks like when the dust settles, how much of a disruption it's going to be, but it's going to have an impact. And ultimately, it will be a force multiplier, and it will have varying effects. I think there are a couple things to kind of keep in mind. One is that legal is a very diverse, in terms of the practice itself, right? Like the tasks that lawyers do, it's very, very diverse.
Stay tuned for the full interview coming to you soon. Between the Briefs is brought to you by Steno. To find out more about Steno and how we combine exceptional court reporting and litigation support services to deliver a superior litigation experience, visit steno.com. That's STENO.com. And then make sure to search for Between the Briefs in Apple Podcasts, Spotify, or anywhere else you get your podcasts, and click subscribe so you don't miss any future episodes. On behalf of the team here at Steno, thanks for listening.